A very good evening to all of you friends. A very warm welcome to each and every one of you from the entire team at BYJU'S Exam Prep on this special marathon round on legal aptitude for Maharashtra CET examination. So if you are in case planning to sit for Maharashtra CET this year, 2022, this session will be of great importance to each and every one. So from the team at BYJU'S Exam Prep, we bring to you this very important marathon round, Maharashtra CET most expected question on legal aptitude and legal reasoning, part 3. So, a very warm welcome to each and every one of you. A very good evening to each and every one of you. I can see a number of students who have joined us by now. It's a very important session and I hope that each and every one of you will be paying a lot of attention in the course of this particular session itself. Now, what are we going to do in this session? Now, precisely, we shall be, number one, discussing certain concepts. Concepts like what is trade union, concept of law, law of contract, necessity, vicarious liability, voluntary non-fit injuria, meeting of the minds relating to law of contracts, guarantee, extortion, absolute liability, and others. So basically, in this particular session today, I am going to talk to you, try to explain to you certain very important concepts of law. Apart from explaining these concepts of law, I shall also try to solve with you certain questions relating to these laws. Okay, so are we ready? Are we all ready? Now, before I begin, I would like each and every one of you to share this session, with your friends so that others can be aware of this particular session that is being conducted from BYJU'S Exam Prep. Okay? So guys, let's begin with today's session. Okay? The first one is the concept of trade union. So in this particular topic, all that I'm going to do is to explain to you about trade unions. Now, what is trade union? Now, in these industries, various industries are there, various businesses are there. Now, you have the employer, the owner of the company, the owner of the business, and then you have the workers who are working. Now, the employer and the worker are not at an equal footing. They don't stand at an equal footing. They stand at a different footing. Now, there is a difficulty insofar as the bargaining power of the workers are concerned. And for this reason alone, we have this concept of trade union. So trade union plays a very vital role insofar as the bargaining powers of the workers are concerned. Is that clear? Now, the management of an industry or the company, they are very powerful, while the workers are very weak. How do the concerns of the workers be heard by the management? Trade unions. Trade unions is the answer. Now let's see a particular provision of trade union. There is this Trade Unions Act of 1926. There's a provision which says that criminal conspiracy in trade disputes is punishable, but an agreement must be between the members for the purpose of furthering any such object of the trade union as is specified in section 15, which is punishable. What is criminal conspiracy? Criminal conspiracy in trade disputes. No office bearer or member of a registered trade union shall be liable to punishment under subsection so and so of the Indian Penal Code in respect of any agreement made between the members for the purpose of furthering any such object of the trade union, as is specified under a provision of the Trade Unions Act of 1926. So precisely this is what is the law. So a member of a trade union cannot be punished in respect of an agreement, made between the members for the purpose of furthering any such object of the trade union. So in case there is an agreement, it cannot be called as conspiracy. Now, let's see what does section 15 of the Trade Unions Act say. Now, section 15 of the Trade Unions Act deals with the object in which generally funds may be spent. Another very important section of the Indian Penal Code. Threatening someone with an injury to his person, reputation or property, or a person and reputation of anyone in whom he is interested, with an intention to cause alarm to that person or to make that person do act which he is not legally, he is forced to do an act which he is not legally bound to do, or omit something, that is called criminal intimidation. So over here we see the principle of criminal intimidation being stated. Okay, so this particular topic of trade union and the relevance of a provision of the criminal law, that is criminal intimidation, has been provided in this particular slide. Am I clear? Is that clear? Okay. So this is what is criminal intimidation is. Please note it down. Whoever threatens with any injury to his person, reputation or property, anyone interested in, that is called criminal intimidation. Okay, is that clear? Every one of you. Okay. What is this explanation? A threat to injure the reputation of a deceased person to whom the person threatened is interested comes within the ambit of this section. So you cannot also make a threat against a dead man. Now, let's look at some of the examples. A, for the purpose of including B, to desist from prosecuting a civil suit, threatens to burn B's house. He says that, look, if you file a case against me in the civil court, I am going to burn your house. Simple. This is called criminal intimidation. So criminal intimidation simply refers to the fact that if you are trying to threaten someone, to do something, okay, that is what is a punishable offense. Let's read a question. Okay, I will move out of the screen so that you can read the question and the facts. There are two important principles given. Read the two principles carefully and then come to the facts. Okay, everyone understood? Has everyone understood the principle, the two principles that are given, as well as the facts? Let's see the question, the options. Has a person committed criminal intimidation? He says that if my demands are not fulfilled, I am going to kill your son. The trade union member has simply said that if the demands are not fulfilled, I am going to kill your son. That is what the trade union man has said. Right? What is the correct answer? Very good. Each and every one of you have given me the right answer. I am very, very happy that everyone has given me the right answer. Okay, the correct answer is option B. Okay, am I clear? Moving on. Now, next important topic is the concept of law. To take the law in one's hand denotes several means, but they all lead to a single conclusion. You are not supposed to take the law in your hand. Suppose a person has committed a murder. Do you have a right to shoot him down? No, you can report it to the police. You are not authorized under the law to take the law in your own hands. It means punishing someone by taking law in your own hand based on one's own idea of what is right and what is wrong, just rather than keeping the faith in the machinery of the establishment is to perform the function. So you are not authorized under the law to take the law in your own hand. It also means doing something illegal, something prohibited by law, by taking law in his own hand. So when a crime is committed, you are no one to give justice. The courts are there, the police is there to provide justice. Read the principle, read the facts, and tell me the correct answer. Now, there is a court of law to punish. In case someone has done something wrong, in case someone has committed something wrong, it is for the courts to punish, not for a village or me or you to give punishment. So the correct answer is, very good, everyone has given me the right answer. Everyone. Is that clear? Every one of you? Each and every one of you. Okay? Did you all understand? So, when you are appearing for an entrance examination like Maharashtra CET, keep all these things in your mind, that these are the important topics. You might be facing some questions from here also. Okay, moving to the next topic. Minors, are they competent to enter into a contract? Now, who is a minor? Below 18 years. Now, what does the law says when it deals with minors? Under the Indian Contract Act, all agreements are contracts if they are made from free consents and parties are competent to contract. If parties are competent to enter into a contract, only then an agreement will become a contract. All agreements are contracts if they are made from free consent and parties are competent. Lawful consideration, lawful object, not expressly declared void under the law. These are the things that have been stated. Now, what agreements are contracts? All agreements are contracts, free consent, parties competent to a contract, lawful consideration, lawful object, not declared void under the law. That is what is stated. Right. Now, every person is competent to contract who is of the age of majority, sound mind, and not disqualified under the law. So, to enter into a contract, the minimum requirement of your age is at least 18 years. So a person who is less than 18 years, can he enter into a valid contract? Question mark. Is that clear? Above 18, you can enter into a contract. Below 18, you just cannot. There are certain exceptions also. Now, what is that exception? Now, the exception to this rule is a minor can enter into a contract only for necessary goods, food. Now, if a poor little boy, a 10-year-old boy, feels hungry, can he not go to a shop and buy a packet of Parle-G? Yes, he can. Suppose a little boy is feeling sick, has fever. Can't he go to a medical shop and buy crocin or paracetamols? Yes, he can. So, over here, minors generally cannot enter into an agreement. Minors generally cannot enter into an agreement, cannot enter into a contract. But there arises a situation where a minor can enter into a contract, but only for necessary goods. Only for necessary goods. That's very, very important. Under the Partnership Act, a minor cannot be a partner in a firm. With the consent of all the partners, he can be admitted to the benefits by an agreement by his guardian with the other partners. So, a minor generally cannot be a part of a firm, cannot be a partner in a firm. But through his guardian, with the consent of other partners, he can share the profits, not the losses. Okay, that is what is stated. Yeah, there's a question number 3 on your screen. Now, I spoke about necessary goods. Necessary goods, a minor can enter into a contract. Tell me. Is that clear? Is that clear, everyone? Every one of you? Okay. Moving on to the next important topic. Necessity. What do you mean by necessity? What do we understand by the term necessity? Necessity simply means something that is necessary to be done. For example, let's say, for example, the law empowers that to stop a larger harm, one can commit a smaller harm. To stop a larger harm, you can commit a smaller harm. Am I clear? Okay. Necessity is a defense which applies in a situation where a person is allowed to act in a wrongful way to prevent a greater harm. So to prevent a larger harm from happening, you can commit a smaller harm. That is what the law says. So to prevent a larger harm from happening, these are the acts that would have been unlawful otherwise, but due to the defense of necessity, it is an exception to the rule. Generally, these laws has an exception. Now, if you trespass into someone else's land, it is a trespass. If you enter into someone's land without his permission, that amounts to trespass. But if you are doing it for necessity, then it is not trespass. It is an exception to the rule of trespass then. Have I made myself clear? Is that clear to each and every one? So guys, I'm sure that you guys are understanding these concepts. It is a question of fact in each case as to whether the harm to be prevented or avoided was of such a nature so eminent to justify the risk of doing the act through the knowledge that caused the harm. So, when you are doing an act which is a civil wrong, you know very well that if you enter into someone else's land without that person's permission, that amounts to trespass. You know it well. Now, you can take necessity as a defense only in a situation where you have committed a wrong to prevent a larger harm. Now, suppose someone wants to kill me with a sword in his hand. So I run from my house, I enter into someone else's house and I am hiding there. Have I committed trespass? Yes, but to prevent a larger harm, my life. Is that clear? Is that clear to each and every one of you? Okay. Now, there is a very important section 81 of the Indian Penal Code, which says any act likely to cause harm but done without criminal intent and to prevent other harm. Nothing is an offense merely by reason of being done with the knowledge that is likely to cause harm, if it is done without any criminal intention to cause harm and is good faith for the purpose of preventing or avoiding other harms to person or property. So here we are seeing a particular situation where the criminal law of the land, which is the Indian Penal Code, which categorically states that if you have committed a criminal wrong, a lesser crime, to prevent a larger crime from being happening, it is absolutely fine. It is a defense. Okay? If the question of fact, it is a question of fact in such a case whether the harm would be prevented or avoided was of such a nature so eminent to justify the excuse of the risk of doing the act with the knowledge which is likely to cause harm. So this is very, very important. I am sure that you guys are understanding. And I'm sure, again, one very important facet is the fact that you must know, intention and motive. Okay. Now, intention happens to be the direct consequence of your action, whereas motive is the far-lying object that you wish to achieve through your intention. Very, very important. Intention is the direct consequence of your action, whereas motive is the object that you want to achieve, the final object that you want to achieve through your intention. Okay? Okay? Is that clear? Example. A, in a great fire, pulls down houses in order to prevent the conflagration from the spreading. So, to prevent the fire from spreading, he topples the house, he pulls down the house. He does this with the intention in good faith for saving human life and property. Here it is found that the harm to prevent was of such a nature and is so eminent as to excuse A's act. So A is not guilty of any offense. Am I clear? Have I made myself clear to each and every one of you? So did you understand the defense of necessity? The defense of necessity in criminal law. All of you. Did you all understand the importance of necessity in criminal law? Okay. Example 2. A captain of a steam vessel suddenly and without any fault or negligence on his part finds himself in such a position before he can stop the vessel. He must inevitably run down to boat B. Now, to save his boat, he has to topple another boat. A situation comes. Within 20 or 30 passengers on board, unless he changes the course of his vessel. And that by changing his course, he must incur the risk of running down a boat C with only 2 passengers on board, which he may possibly clear. Now, there is an option with a seller that either I pull down boat A or I pull down boat B. Either ways, if I have to survive, I have to do either of the two. Is it necessity? The answer is no, it is not necessity. Here, if A alters the course without the intention of running down boat C, in good faith for the purpose of avoiding the danger to the passengers in boat B, he is not guilty of any offense. Though he may run down boat C, by doing that act, he knows that if he is found as a matter of fact that the danger which is intended to avoid was such to excuse him for incurring the risk to pull down boat C. Understand? Understand this. Very important. Very important. Okay, all of you. Everyone, is it clear? Understood? There's a question up there on your screen. Question number 4. Is it necessity? Is this necessity? Now, another very important thing, was there any criminal intention? Mens rea. For a crime to take place, there must be both mens rea as well as actus rea. For a crime to take place, there has to be both mens rea and actus rea. Right? Was there any criminal intention on the part of the faculty, on the part of the teacher? So the correct answer is, all of you, very good. There was no intention. Is that clear? Did you all understand? All of you. Any doubt? Any doubt that you guys have? Okay. Let's move ahead. The next topic is the concept of vicarious liability. What is this concept of vicarious liability? The concept of vicarious liability states that generally under the law, under the general law, if Mr. A commits a wrong, Mr. A is held liable. Mr. B commits a wrong, Mr. B is held liable. Mr. C commits a wrong, Mr. C is held liable. So generally under the law, if Mr. A commits a wrong, Mr. A is held liable. If Mr. B commits a wrong, Mr. B is held liable. Now we are talking about this concept of vicarious liability, which means that for the wrong committed by Mr. A, Mr. A is not held liable. For the wrong committed by Mr. A is not held liable, but someone else is held liable. How does it happen? It happens under a couple of situations. Master-servant relationship, principal-agent relationship, and partners in a partnership firm. So for the wrong committed by the servant, the master is held liable. For the wrong committed by the agent, the principal is held liable. and for the wrong committed by one of the partners, other partners can also be held liable. Now suppose you have asked or you have authorized your servant to do a particular act. Suppose you have authorized your servant to do a particular act. Now while doing that particular act, if he commits a wrong, who is held liable? The master, because he had authorized his servant to do some act. Now let's see certain very important aspects. A principal is liable for the wrong committed by the agent during the course of employment. One can be considered as an agent if another remunerates and exercises direction and control over the other. Vicarious liability extends to acts done in the course of agency where the agent is working under the instruction of the master. Okay? Is that clear? All of you? Sorry. Is that clear? So guys, before moving ahead, if you're liking this session, do press the like button. If you're liking this session, do press the like button. Okay? That's very, very important. And do share this session with your friends so that, they can get help from these important classes that we are conducting. Another very important aspect, it does not extend to acts done outside the course of employment, course of agency, and acts done after the termination of agency. Is that clear? When a person engages another to act on his behalf, a relationship of the principal and agent is created between them. Okay. Let's come to question number 5. Muskan says, sir, if someone asks his friend to drive a car and an accident happens due to negligence of the friend, who will be liable? The person who asked the other person to drive the vehicle will be held liable under civil law, under the concept of vicarious liability. But under the Motor Vehicles Act, the person who is driving will also be held liable. Okay. Yeah. So let's see. Okay, everyone is saying B, 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 B. Okay. If you are saying B, what can I do? If you have said B, then the answer will have to be B. Is that clear? The answer will have to be B. Okay. Everyone, is it clear? Every one of you. Any doubt? Okay. The next concept of guarantee. So what do you mean by a guarantee? Suppose I go to a bank and I tell the manager of the bank that I require 100 crore rupees as a loan. Will the bank give me 100 crore rupees as a loan looking at my face? Suppose I go to a bank and I say that I require 100 crore rupees as a loan. Give me 100 crore rupees as a loan. Will the bank give me a loan of 100 crore rupees? The answer is no. The bank will not. The bank will not. Now, what happens? What can I do? The bank manager tells me that, look, I can give you a loan. But provided you bring someone who will act as a guarantor of this loan. That means he says that if I fail to pay back the loan, somebody else will guarantee that the payment is made to the bank. Somebody else says that in case I fail to pay back the loan, he is going to pay back the loan. That is called the concept of guarantee or the contract of guarantee. Am I clear? Every one of you. Are you guys understanding these particular topics? Okay. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. So the bank is the creditor, the principal debtor is me, and the person who is guaranteeing that if I fail to pay back the loan, he is going to pay back the loan. He is called the surety. He is called the surety. Am I clear? So the surety promises the bank that in the event the principal debtor fails to pay back the loan to the creditor bank, then he is going to pay back the loan. A guarantee can be either oral as well as in writing. Don't ask me this question, how to prove, because you don't know evidence law. So a contract can be both oral as well as written. Okay, that's very, very important. Contract of guarantee, surety, and principal debtor and creditor. Okay, let's see. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in the case of his default if he fails. The person who gives the guarantee is called the surety. The person in respect of whose fault the guarantee is given is called the principal debtor. Okay, principal debtor, the person who is asking for the loan. And the person to whom the guarantee is given is called the creditor, that is the bank. Am I clear, all of you? Is that clear, everyone? Every one of you? Please note it down. And I'm sure that you guys are, as I speak, you guys are noting down these important things. Okay, everyone? Okay, all of you. Question number 6 is up there on your screen. Question number 6 is up there on your screen. Let me move out of the screen so that you can read the question very carefully. Read the question very carefully. The principle, the facts, and the options. Is that clear? Have you read the principle? Okay, the principle is over here. The facts A took a loan and defaulted. Is this what we call as a guarantee or surety? Does this fact deals with guarantee? The answer is no. What is the correct answer? Option D. Option D is the right answer. There is no guarantee. There was no guarantee. Is that clear? Is that clear to each and everyone? Am I clear, all of you? To each and every one of you who is watching me now, have I made myself clear? Now, what is a person who gives a guarantee is called a surety. The person in respect of whose default the guarantee is given is called the principal debtor. Now, A took a loan and defaulted. The bank threatened to sell his security. C gives guarantee on behalf of A. Now, after a person defaulted, can there be a case of guarantee? No, it cannot be. Prior to the default, during the agreement, there has to be someone who is seeking as a guarantee. Okay, so the correct answer happens to be option D. The next concept, Volenti non-fit injuria. Now, what do you mean by Volenti non-fit injuria? Volenti non-fit injuria means if you have voluntarily taken up a risk, you know the risk involved. Even after knowing the risk involved, you participate and then you suffer some injury. Can you claim compensation? The answer is no. So you cannot claim compensation in case you suffer an injury which you have yourself consented to. Now, there is a fire that is burning. You know that if you touch the fire, if you keep your hand on top of the fire, you might suffer some injury. Even after that, you put your hand on the fire. You put your hand on the fire. Can you claim compensation? Can you claim compensation? No, you cannot. That is what we understand by the principle of volenti non-fit injuria. As a general rule in law of tort, if a person commits any wrong that causes injury to another person, he is held liable to pay damage. Now, the damage is unliquidated, that is, it is to be determined by the judge. So, court is going to determine how much money you will have to pay as compensation. Is that clear? Volenti non-fit injuria is a Latin maxim which means to a willing person it is not a wrong. To a willing person it is not a wrong. So if you have willingly participated, you know the risk of a game, you participate in that, it is not that you can claim any compensation. Volenti non-fit injuria is a defense wherein the plaintiff is not entitled to recover damage because he consented to the act which caused him injury. Okay, so if you have consented to the injury that has been caused. Now, suppose you buy a ticket for an IPL match. Suppose you have bought a ticket for an IPL match. You are reading, you sit in the gallery. Now, if someone hits a 6 and the ball travels across and hits your head, can you claim compensation? Can you claim compensation? The answer is no, because the moment you buy the ticket, you accept the risk of sitting inside the stadium, and you know that in a cricket match, somebody can hit a 6. Somebody can hit a 6. It's known. That is precisely what we mean, or rather what we understand by the concept of volenti non-fit injuria. Am I clear? Everyone. So volenti non-fit injuria is a very, very important topic, because we see that in most of the examinations, questions which come from law of tort revolves in and around the 8 defenses: act of God, necessity, statutory authority, private defense, and others. So these are those defenses under law of tort, and the most expected questions do come from these various defenses. Am I clear? Any doubt? Any doubt? You are most welcome to ask me your doubts. Yeah. Please tell me in case you have any doubts. Okay. So there is no doubt from you guys. Fantastic, fantastic, fantastic. So let's move on to the next question. Question number 7 is up there on your screen. You have a flat near a stadium. You know that in that particular ground people are playing cricket. There will be some Rohit Sharma as well as Virat Kohli who might hit those 6s across. And even then you do not install any grill. You are hit on your head. What is the correct answer? What is the correct answer to this particular question? And the answer is can you claim compensation if you are hit? Can you claim compensation if you are hit? No, because you knew very well the risk involved in that flat. If you knew that there is a stadium next door, normally you will put those grills in the windows to prevent a ball from getting in. Is that clear? Is that clear? All of you? So the correct answer is option B. Option B is the right answer. Okay. Any doubt? Any doubt that arises from this particular topic of volenti non-fit injuria? Okay. One more thing is the fact that, before I forget, having said that, there is an exception to the rule of voluntary non-fit injuria. And what is that? Rescue cases. Now, suppose you are entering into a building which is on fire to protect or to save someone, to save someone, then you can definitely claim compensation. You can definitely claim compensation. Okay. Is that clear? Is that clear, all of you? All of you. Any doubt? So now, before moving ahead, I have certain very important things to say. I have certain very, very important thing to say. Now, guys, I'm sure that most of you have already downloaded our our BYJU'S exam prep app, right? So I'm sure that all of you has already downloaded the BYJU'S exam prep app in your mobile phone. If you have downloaded, then what do you get? You get a number of free videos, a number of free questions, mock test. So we are providing you number of free videos, good amount of material for your preparation for the law entrance examination. All you need to do is just download the BYJU'S exam prep app. So download the app today itself. Yeah. Please explain the exception. The exception to the rule of Volenti non-fit injuria is rescue cases. Now, if you are, now, you know that a house is on fire, and you know very well if a house is on fire, and if you enter the house, you might suffer some injury. So what do? You enter the house knowing very well that if you enter the house, you might suffer some injury. Now, what is the reason for you to enter that house? To protect someone, to save someone. So if your intention is to save someone, rescuing someone, it is not a case of voluntary non-fit injuria. Okay? It is not a case of voluntary non-fit injuria. Am I clear to each and every one? Okay. Okay, all of you. The next concept, communication insofar as contract is concerned. An offer, an acceptance, both has to be communicated. Now, suppose I have made an offer. That offer is required to be communicated to the acceptor, and the acceptor's acceptance needs to be communicated to the offerer so that the offerer knows that someone has accepted his offer. That is precisely what we term as communication insofar as law of contract is concerned. So insofar law of contract is concerned, insofar as law of contract is concerned, it is absolutely important. It is absolutely important for each and every one of us to know that an offer has to be communicated. Similarly, an acceptance is also required to be communicated. It is not only that an offer is required to be communicated. At the same point in time, please try to understand that an acceptance is also required to be communicated under the law. Let's see. The Indian Contract Act says that the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. I have made an offer to Mr. A. I say I want to sell my house for 50 lakh rupees. The moment Mr. A hears it or it comes to his knowledge that is when the offer is complete. So offer is said to be complete, or a proposal is said to be complete when it comes to the knowledge of the person to whom it is made. Am I clear? Is that clear? Is that clear? Next, communication of an acceptance is as against the proposer is complete when it is put into the course of transmission. The moment you put the letter, the moment you put the letter, the moment you put the letter, the moment you put a letter of acceptance in the letterbox, your thing is complete. It is complete from your end. But when it is complete from the end of the acceptor, of the proposer, when it comes to his knowledge. So communication of acceptance as against the acceptor is complete when it comes to the knowledge of the proposer. But over here, communication of acceptance as against the proposer is complete when it is put in the letterbox itself, especially when you are writing a letter. Offer. Is that clear? Have I made myself clear to each and every one of you? This is what is communication. Please read it. I'll give you 2 minutes time. A communication be revoked? Somebody has asked this beautiful question. When can communication be revoked? Before the proposer has accepted your acceptance. Suppose I am the offerer. I have made an offer to you in a letter. I want to revoke it. So what do? I have sent that in a normal post. So I send a revocation letter in a speed post before the offer reaches you. It reaches my revocation reaches you. Is that clear? Have I made myself clear? Once accepted, it cannot be revoked. Yeah. Once an offer is accepted, it cannot be revoked. Yeah, correct. Okay. Communication of revocation is complete as against the person who makes it when it is put into the course of transmission to a person to whom it is made, and to be out of the power of the person to whom it is made as against the person to whom it is made when it comes to his knowledge. So before the offer reaches the acceptor, the proposer or the offerer can revoke his offer. Before the acceptance reaches the proposer, the acceptor can revoke his acceptance before the acceptance reaches. That's it. As simple. Please explain in Hindi. ठीक है? To explain in Hindi, I would say that जब अगर मैं आपको एक ऑफर देता हूं, सपोज मैंने एक ऑफर आपको दिया, आई वॉन्ट टू सेल माई हाउस फॉर 1 लाख रुपीज, उसको मैंने नॉर्मल पोस्ट में डाल दिया, इनलैंड लेटर में, आपको पास पहुंचने में 4 दिन लगेगा. इफ आई हैव टू रिवोक, मैं एक स्पीड पोस्ट करके मैंने बोला कि मेरा एक ऑफर लेटर है जो आपको पहुंचने वाला है 2-4 दिन में, उसको मैं कैंसिल करता हूं. सो दैट इज कॉल्ड रेवोकेशन. That is what is precisely we refer as revocation. Is that clear? Okay. Example. A proposes by letter to sell a house to B at a certain price. A proposes by a letter to sell the house at a certain price. The communication of the proposal is complete when B receives the letter. The communication of the proposal is complete against A when B receives the letter. Is that clear? Is that clear? All of you. Everyone. Have each and every one of you understood? B accepts A's proposal by letter sent by post. B accepts B's proposal by a letter sent by post. The communication of the acceptance is complete. The communication of the acceptance is complete as against the agent when A, the letter is posted, as against A when the letter is posted, as against B when the letter is received. Is that clear? If you sent a mail of acceptance and then you want to revoke, all you can do is to pray to God that the other person has not opened that inbox, has not read your email, and before he reads that email, you call him and say that I have mistakenly sent you an offer or an acceptance. Please do not take it seriously. That's it. Okay? Vaibhav Singh. All of you. A certain price, valid for a certain price. Yeah, it was written on a certain price. So do not just get yourself confused. 50 lakhs, 10 lakhs, that is a certain price. Okay, don't worry about that. Everyone. A revokes his proposal by telegram. The revocation is complete as against A when the telegram is dispatched. It is complete against B when B receives the complete as against B. So as against B when B receives it. That's it. Now how to prove things, don't worry. How to prove things, how not to prove things, leave it to lawyers and judges in the court. All of you. Is that clear? Everyone. Everyone. Read this. B revokes his acceptance by telegram. Now B's revocation is complete against B when the telegram is dispatched and as against A when it reaches him. B revokes his acceptance by telegram. B's revocation is complete as against B when the telegram is dispatched and as against A when it reaches him. That's the most important thing. Understand this. Okay? Any doubt? Now, these sessions, guys, are very important, and I'm sure that you guys are taking notes, understanding these topics, because if you get some question from these topics, just don't say that, you know, sir taught us, but, you know, you just missed it. No, that can't happen. Because this is an entrance examination. Everyone will be working hard to get into the top law schools of Maharashtra CET, GLC Mumbai, ILS Pune. The next question, question number 8 is up there on your screen. I'll just move out of the screen. The correct answer, people are saying 8A, 8A, 8A. Yeah, it is. The acceptance is complete. The acceptance is complete. Have I made myself clear? Now, these questions that we are solving right now, they are not difficult at all. So, you know, if you know the law, if you can read the principle properly, if you can read the facts properly, it will not be difficult for you to solve a particular question. It shall not be difficult for you to solve a question, provided you understand a principle and you understand a fact. Now, if you get jumbled up, then it is difficult. Then it will be difficult. Then in that event, it will become difficult. Am I clear? Is that clear, everyone? Okay. So all that I'm trying to say is the fact that if you concentrate and if you have put in some good amount of hard work, insofar as your preparation for this examination is concerned, it will not be difficult for you. That is what I would say. Meeting of minds. When we are entering into a contract, there must be meeting of the minds. People must think same in the same sense. So parties to a contract must have meeting of the minds. They must think in the same way as the other party is thinking. Suppose I say, I want to sell my house. Now suppose I have 5 houses. One in Delhi, one in Noida, one in Patna, one in Madras, Chennai, the other one in Bombay. I think I want to sell my Delhi house. You think that I am selling my Mumbai house. Is there meeting of the minds? Are there meeting of the minds? No. I want to sell my Delhi house. You think that I am selling my Mumbai house. There is no meeting of the minds. There is no meeting of the minds. In case there is no meeting of the minds, there cannot be a valid contract. That is what the Indian Contract Act categorically states. One of the essential elements for validation of a contract is meeting of the minds of the parties. There must be a consensus at item. There must be meeting of the minds of the parties who are entering into a contract. There must be a meeting of minds when we are entering into a contract. Very important. For a contract to be legally binding, there must be meeting of all the parties involved. There must be meeting of the minds of the parties involved. Unless and until there is a meeting of the minds, there cannot be a valid contract. That is something that you all and we all must try to understand. Have I made myself clear? Now, okay. Both the parties must be clear as to what is offered and what is being accepted. So everything should be transparent, clear. There must be clarity in the offer. There must be clarity in the acceptance. There cannot be a situation where there is an ambiguity or a doubtfulness involved. No doubts are involved in a contract. Okay, all of you? Any doubts? Okay. A question. Question number 9. Are there meeting of minds between the two parties? I have 2 plots of land. I say that I want to sell my land. You think that I am wanting to sell both my lands, but I think that I am selling only one land. Are there meeting of the minds? No. There is no meeting of the minds. There is no meeting of the minds, and hence option B is the right answer. Okay. Another very important concept. Willful release of a contagious dog. Sorry. Whoever keeps an animal has a duty of care towards others that might hurt due to the breach of the duty of care of the owner. Now, so suppose, I'm sure that you must have seen houses of people in which there are dogs, ferocious dogs. They say that beware of dogs. In the gate itself, they have said, in the entrance itself, they have said, beware of dogs. That means it is the duty of the owner of a dog to make sure that others are not harmed. Others gets a precaution that a dog is present in a particular house. Is that clear? Okay. Next question. Question number 10. So simple question. It is on the face. What is the correct answer, all of you? Okay, I'm getting answers from, okay, good. Option A, 10A. Siddhi, Vaibhav, Afshin, Vaibhav, Sanya, Abhishek, Harsh, Angel, Dhaneshri, Amit, everyone, it is punishable. If everyone is saying option A, how can I not say option A? Yes, it is option A. It is option A. It is option A. Am I clear? Everyone? Any doubts? Okay. So, before moving ahead, these classes, I'm sure, are being very helpful to you. All that we want is one like from you. So do like the session, do share this session with your friends who all are also preparing for Maharashtra CET. You don't have much time for this examination, it's coming this weekend. The next topic is called extortion. What is extortion? Whoever intentionally puts another person in fear of injury to that person or to any other person and thereby dishonestly induces him to deliver some valuable security, anything signed or sealed which may be converted into valuable security is said to have committed extortion. So now, suppose I have kidnapped Mr. A's son. Suppose I have kidnapped Mr. A's son and I call Mr. A and I say that if you do not give me 5 crore rupees, 1 kilo of gold, I will kill your son. This is what is called extortion. You are putting someone under a fear of an injury to that person or any other person and thereby dishonestly inducing the person to deliver something which is of value. That is precisely what we understand by extortion. Okay, please note it down. 1 minute for you. Is that clear, everyone? All of you? A threatens to publish a defamatory libel concerning Z unless Z gives him money. So he is saying that I am going to publish something which will defame you if you don't give me money. That is called extortion. That is called extortion. Is that clear? So did you understand the pure meaning of what is extortion? If you are doing something whereby you are inducing a fear on a person and you are asking that person to give you some valuable security, that is called extortion. A threatens Z that he will keep Z's child wrongfully confined unless Z signs and delivers to a promissory note binding Z to pay certain money to A. Now you say that I am going to leave your son, I have kidnapped your son, I am going to leave your son if you only give me a promissory note. Extortion. That is called extortion. This is what we understand by extortion. Okay. A threatens to send clubmen to plow up Z's field unless Z signs and delivers B a bond binding Z under a penalty to deliver certain produce to B. This is also called extortion. Simple. We are giving you examples which will help you to understand a concept easily. Okay. The fourth example. A, by putting Z in fear of grievous hurt, dishonestly induces Z to sign or affix his seal to a blank paper and deliver it to Z. He signs and he delivers that paper to A. A has committed extortion. He has committed extortion. This is what we categorically understand or precisely understand by the term extortion. Any doubt? Question number 11. (11A), (11C), C. Okay. Let's see the correct answer. Another 30 seconds for you. Where has A committed extortion? He says, if you want to meet your daughter, give me 5 lakh rupees. The daughter was in a cinema hall. What is this extortion? Just a bluff. Next, absolute liability. If you bring on your land something that is dangerous, something that can escape, something that is hazardous, once that escapes out, it causes misery to hundreds and lakhs of people. Bhopal gas leak tragedy, Oleam gas leak tragedy, Vishakhapatnam tragedy, Vizag, LG Polymers. Both civil law and criminal law. It is when a person is held liable for committing an act regardless of his intent or other things. When a person brings and keeps something that is a dangerous substance in his land and such substance escapes and causes injury to the other, it comes under strict liability. There are certain defenses under strict liability. There are certain defenses under strict liability. Note it down. Okay. In strict liability, there are certain defenses. Now, these defenses are act of God, plaintiff's fault, act of third party, and consent of the plaintiff. Now, strict liability minus the defenses gives rise to absolute liability. The rule of absolute liability evolved in MC Mehta versus Union of India. That is the famous oleum Gasly case that happened in Delhi. Let's read a question and try to understand. I'll just move out of the screen. So that you can read the things properly. Okay. Yeah. Read the principle carefully. Let's see whether M is liable or not liable. Is that clear? Okay, Oshini Gupta says C. No, it is not C. D is liable. How? No. Am I clear to everyone? M's responsibility was insofar as the safety is concerned. Please read, guys. This is not done. Read. M had the full responsibility for safety. Then how can you say that D is liable? No, it cannot be. Read properly. See, your answers are there in the question itself. All you need to know is to understand. Okay, all of you. Okay. The correct answer is option A. Moving on. Oh, wow. These are some legal knowledge questions. How many Lok Sabha constituencies are there in Meghalaya? 3, 2, 4, 5. How many people in the Lok Sabha comes from Meghalaya? How many people? Good. 2B. Correct. Okay. (14) Who appoints the Secretary General of Rajya Sabha? Who appoints the Secretary General of Rajya Sabha? What is the correct answer? Who appoints the Secretary General of Rajya Sabha? Rajya Sabha Chairman. The Chairman himself appoints the Secretary General of Rajya Sabha. Is that clear, everyone? Is that clear to each and every one of you? Next question. As per Article 64 and Article 89(1), who shall be the ex officio chairman of Rajya Sabha? Now, Council of States means Rajya Sabha. Who is the ex officio chairman of Rajya Sabha? Vice President, President, Governor, Chief Minister. Shri Venkaiah Naidu. Shri Venkaiah Naidu is the Vice President as well as the Chairman of the Rajya Sabha. That is what? Okay. Next comes voluntary non-fit injuria. Generally, the law says that if you suffer an injury, the other person for whom you have suffered an injury will have to pay compensation, unless it is for voluntary non-fit injuria, when you know the risk involved, and even then you don't pay attention to the risk, you participate and you suffer an injury. That is what we precisely understand as voluntary non-fit injuria. Okay, so to a willing person, nothing is a wrong. I think this has been already discussed with you. Okay. I think 16. What is the correct answer? Please tell me what is the correct answer. Every one of you gave me the right answer. Most of you have given me the right answer. Congratulations. Many, many congratulations to each and every one. Okay. Okay. The next concept, indemnity. Insurance. I think we did it yesterday itself. Insurance. To make good the loss. So if you think that you might suffer some loss, owing to an activity, you can protect your loss through an insurance or through an indemnity. That is what we call as indemnity. According to the developed practice, indemnity is limited to exclude losses caused by the accountable body's negligence, and it can only be invoked only once the accountable body has made a reasonable endeavor to recover any reclaimed grant from the relevant project manager, which may include taking any legal action. A contract by which one party promises to save the other from losses which can be caused to him. That is exactly what we understand as indemnity. So indemnity precisely means that if you are protected, if you stand protected from a loss that might incur in future. Insurance, life insurance, fire insurance, accident insurance, burglary insurance, theft insurance, that is what we understand as indemnity. Okay. Is that clear, everyone? A contract to indemnify B against the consequence of any proceeding which C may take against B in respect of certain sum of rupees 200 is a contract of indemnity. This is what we understand precisely by indemnity. Let's solve a question. Let me move out of the screen. This is what is called negligence. The correct answer is option D. Option D happens to be the right answer. Substandard truck. That's it. That was enough to come to this conclusion. Okay. Moving on. Wow. Which part of the Constitution deals with Panchayati Raj institutions? Tell me fast. The correct answer is very good. It is Part 9. Part 9 of the Indian Constitution deals with the Panchayati Raj institutions. Next question, question number 19. The 22 languages, the scheduled languages which are given under the Constitution comes under which schedule? The 8th schedule. The 8th schedule. Have I made myself clear? Okay. The next question, question number 20. Which of the following amendment introduced the concept of goods and services tax in India? Wonderful question. 20. GST was introduced in India by which of the following amendment? GST came in the year 2016. So this and this is wrong. Either this or this. Okay. Now, Hundred and first constitutional amendment, 101st constitutional amendment, 101. The 101st constitutional amendment. Okay. Is that clear? Everyone? Is that clear to each and every one of you? The next question. Very easy question. Everyone knows. What is the correct answer? I want her name. I want the President of India's name in the chat box right now. Who is the President of India today? What is her name? The first tribal President of India. Srimati Draupadi Murmu. Srimati Draupadi Murmu is the present President of India. President. Am I clear to each and every one? Have you all understood? So, to do well in this examination, you have good amount of legal knowledge and legal reasoning. That's it. You don't need to know anything more. Okay. So, the correct answer is none of the above. Draupadi Murmu. Okay. So guys, with this, we come to the end of today's session. Do follow us on our Instagram, YouTube, Facebook. Join our Telegram channel. And do not forget to download our app. Unless and until you download our app, you will not get all the most of the materials which are free only after downloading the app. So download our app and get a lot of surprises from BYJU'S exam prep. I wish you all the very, very best for your examination. I believe that you have prepared well in the last couple of months. You will do well. Have the courage in you, have the confidence in you that you will do it good. Okay? All the very best. Take care. Bye-bye. All the very best. I pray to God that each and every one of you watching this session will get through Maharashtra CET. Okay? And do not forget to share this session and do not forget to press the like button and subscribe to this lovely channel meant just for your education. Thank you. Bye-bye. Take care. See you soon. Bye-bye.